When a patient calls LawMD, one of the first things we do is we evaluate the case on its merits. Part of that is requesting medical records. The medical records will be sent to us. We'll take a very, very close look at it and determine whether this is a case that can go forward. First of all, we don't want to waste your time if it's not a case we can help with. But on the other hand, if there's a case that we really feel it has merit, then we will move forward after evaluating the case. One of the steps in a medical malpractice case is deposition, right? So we have a case that comes to us, we get the medical records, we examine the medical records very carefully, we establish those 4 elements that we talked about in terms of duty, breach of the duty, causation, and then damages. Get to that point, but the medical malpractice lawsuit actually goes on for a while, and there's lots of very complex steps along the way. One of those is the deposition, where our side gets to ask questions of the anesthesiologist that was involved, as well as the anesthesiology expert. So in those depositions, we get to ask them questions, and they are under oath and have to tell us honestly what is happening. And in those instances, being an anesthesiologist myself, I'm able to understand when they're maybe blurring the line, or maybe not saying as much as they want to say, or whether they're outright lying, or they have something to hide. Because I do the same thing they do. So I know when they're not exactly being totally truthful with me. And then when we go to depose the anesthesia expert for the other side, I can tell them and I can rebut all of their literature that they may be citing, because I'll have my own literature. So we can neutralize the anesthesiology expert, and we can also figure out whether the anesthesiologist has information that they may be withholding from us.